This is a blog, virtual blog, for the second edition of my book, Global Governance, Human Rights, and International Law, with the subtitle Combating the Tragic Flaw. It is in the Routledge Research in International Law series. And the reason why I did both the first and the second edition was I wanted to bring out a view that global governance, and indeed the perspective of many countries around the world, their perspective on their role in the international community and in international law is based on a profound misunderstanding of the concept of sovereignty. In the book, I start the first and second editions with the view that the understanding by modern international lawyers and indeed modern international statements that the concept of sovereignty was based on the 1648 convention at Westphalia was misinterpreted by having the meaning of sovereignty being the absolute autonomy of those who govern. In the context of the Westphalia treaties, the estates, which then became independent countries, they would have absolute autonomy, untrammeled autonomy to do whatever they wanted within their jurisdiction. In fact, some of the best minds in history have pointed out that that's not actually what the Treaty of Westphalia stands for. It actually stood for, after the end of the 30 Years' War, and with the disintegration of the Holy Roman Empire, a requirement for emerging nations to be able to respect the minorities within other neighboring parts of what was the Holy Roman Empire, and on that basis to respect the minorities within their own jurisdictions, and indeed have an understanding of a form of international rule of law. And it is my view that that's what the Treaty of Westphalia should really stand for. It was the first beginnings of an international rule of law and indeed an international constitution, which required the emerging countries of Europe to basically understand sovereignty as a responsible exercise of governmental power, which means also respecting the rights of its citizens and especially the rights of minorities within its jurisdiction. Sadly, however, that was not taken to mean the fundamental basis of sovereignty by many of the architects of public international law in Western Europe, which sadly was then expanded through the colonies of the European empires to expand that to the definition of sovereignty of not just the empires of Europe, but then when those colonies became independent, they regarded that on becoming sovereign nations themselves, they would also have this concept of absolute sovereignty. And in my book, I focus on how the present system of international human rights law and indeed international human rights policy is profoundly beset with this tragic flaw, which still regards national sovereignty as the basis of absolute autonomy for those who govern a country to do whatever they want, whereas the original meaning of the Westphalia treaties was that it was the beginnings of an establishment of the international rule of law, where individual countries would basically regard sovereignty as a respect of the rights of the citizens within the jurisdiction and the minorities therein. So in the first chapter, I talk about how sadly the tragic flaw was exported to the UN Charter, which again, in its very most important articles, Article 2.4 and Article 1, which basically says that the UN is founded on the independence, territorial independence of each nation, and political independence, which has taken to mean absolute sovereignty for those who lead these countries, without understanding that that very concept was the basis of an establishment of the rule of law. So I show how the international human rights system is beset with this tragic flaw, and as a rule, is essentially having many, many challenges from the time that the charter was first put in place to the huge amounts of human rights violations during the Cold War, to the emergence of the genocides we see in the 20th and 21st, and this very first century, 21st century, and indeed now we see the failures of some of the superpowers, including Russia and China, to understand that the concept of sovereignty doesn't mean they can do whatever they like within their jurisdictions, or indeed, as we see with Russia, with neighboring countries. So that is one of the main reasons why I had both the first and the second editions focus on this fundamental tragic flaw of international public law, and indeed of the understanding of nations in terms of the concept of sovereignty. In the second chapter, I talk about how sadly this tragic flaw emerged also even in the international trade system, where essentially in the international trade system, the most powerful essential engaged in a form of beggar thy nation, beggar thy neighbor, by essentially only agreeing to negotiate on the basis of mutual advantage, and not understanding that within each country, the most vulnerable also need to be respected in terms of labor rights, human rights, and indeed, as we see more recently, to also understand that the international trade system must also respect the environment, because ultimately a failure of the global environment will be the most ultimate form of the violation of international human rights law. In the third chapter, I show that there was a profound omission to regulate and make sure that the most emerging powerful entities in the world have to be subject to a form of international rule of law. And in particular, I talk about the global private sector, and I demonstrate how if they do not act responsibility, they could have profound impact on a whole range of human activity in terms of the environment, in terms of human rights, in terms of corruption, and indeed in undermining the entire economic system, which results then in potentially global financial crisis. And then finally, I talk about how if we are going to essentially get a new understanding of the concept of sovereignty, and a new understanding of how that concept of sovereignty as a responsible exercise of governmental power, we need to have at the global governance level a more pluralistic understanding of what governance is, what the role of international multinational institutions have to pay attention to in terms of promoting a pluralistic understanding of nations, and indeed understanding even within nations there needs to be a plural understanding of how institutions of global governance have a profound impact on not just nations but those who live within nations. So that's basically a summary of what the book is all about, and I highly encourage you to read it, think about it, and I'll be delighted to discuss with anybody what they see as the challenges that I put forward, or possibly the failures of this approach to public international law. So I look forward to any reactions that those who are viewing this vlog will come up with, and I'll be happy to enter into that discussion with them. Thank you very much.